Today's date is July 5th, 2022. As you can see, today's panel is Judge Hensel, Judge Callahan, and myself. This morning, we are going to hear oral argument on one case via Zoom. It's case number 21CA0084-M, Jones versus BRP/RICO Manufacturing. Each party will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. I'm going to be keeping track of time, so just let me know how much time you want for rebuttal, and I'll let you know as you get close, Attorney Conway.
Okay,
the arguments are recorded, so we ask that you keep your voice up, and they are also posted on our YouTube channel, so it's available to the public there. We've read the briefs. We're prepared to proceed if you are. Would you like to reserve some time, Attorney Conway?
Yes, sir. 5 minutes is fine.
5 minutes. All right. I'll let you know as you approach that. You may begin.
Thank you. For the record, I am Mike Conway. I'm the appellant's counsel. I represent Darryl Jones in this lawsuit against BPR-RICO. This case basically is about the defendant, through its agents, offering my client a raise, promising him a raise, and then not paying it after he did the work to get it. This is distinguished from a situation, for example, an authority cited by the defendant where someone's not promised anything and the reliance on a promise that doesn't exist breaks the case. That's not the situation here. The evidence is that, the undisputed evidence is that my client, who's an engineer, a mechanical engineer, designs lift trucks for the defendant, was very good at his job. He'd worked for the company about 2.5 years. He never got a raise. Back in October of 2017, he had a performance review, and the other side made it clear they wanted him to stay and they were going to promote him and groom him for a higher position. They said that, you know, he was getting a raise. My client continued to work for it. Then in January 2018, he got increased job duties. He became a CAD administrator as computer-assisted drawing and ERP, Enterprise Resource Planning, which is a software management job, in addition to his old engineering jobs. And again, he was not given a raise. He continuously asked for the raise that he told he was getting, and he was continually put off. It all came to a head in June of 2018, where he had a meeting with Jesse Clues, who became his boss for a whopping total of about 1.5 weeks. And he was put on a performance improvement plan, as evidenced by our Exhibit 13, Plaintiff's Deposition Exhibit 13, Defense Exhibit 8, where you know, they even talked about in the performance improvement plan, you know, here's the policy for granting raises. And the discipline that got him fired was directly related to him insisting that he get paid his raise. Now, the other side's, you know, position is that, oh, well, that there's no estoppel here, no clear promise was made. No, that's not correct. He was promised a raise for 8 months and didn't get it. The issue with how do we calculate that raise is a remedies question. It's not a promise question. The other side said, Clues said that he uses some book, and it's discussed in the brief in detail, where he testifies about how he used some book to calculate average raises for engineers like my client. What's interesting about that is my client wasn't requesting just a COLA, cost of living adjustment. He's requested a merit raise. It wouldn't matter if there was some book discussing raises or not, but the point that one exists shows us the other side had a way of calculating raises and wouldn't give them one. These facts are at least as reliable as those in Mares versus Columbus Dispatch, where the plaintiff in that case was suspended from his job because of a criminal case against him, and was told, if the case is resolved in your favor, you can have your job back. Case was resolved in his favor, didn't get his job back. And the high court said, wait a minute here, you made a promise. Now, interesting about that is Mr. Mares had an at-will employment relationship with the Columbus Dispatch. And so it talks about, if you promise somebody you're going to give them a job, you got to give them a job. Well, how is that not at least what we're dealing with in this case. The idea that the defendant's view that because my client was an at-will employee, just as Mr. Maris was, because he's an at-will employee, he's not owed anything, trying to make this case into a wrongful termination dispute when it's not pled that way in the complaint is a reversible error. It was a reversible error on the trial court's part to treat it that way. The trying to make this case into an at-will employment dispute sends it in the wrong direction. That's not what this case is about. This is about, I did work, you said I would get a raise to do the work, I didn't get the raise. That's really it. It also can be argued that his performance creates an implied contract situation, just like failure to pay a bonus under a unilateral contract where someone says, if you work here, these were the facts in the Harwood case argued in Southern District of Ohio. If you work here and you stay here, we'll pay you a bonus. The plaintiffs in Harwood did that, and then they got fired, right at the last minute, saying, "Oh, you're at-will employees. We don't owe you anything." So what I really like this court to do is to send a message that the at-will doctrine is not a defense when you promise somebody a benefit of employment. These cases do not have to be wrongful termination cases. If someone works for a raise and they do the work and then don't get the raise with this ridiculous theory that, either you're paid well enough or you're an at-will employee, then that will result in injustice. It's not fair to my client. It's what the other side did is deceptive and misleading, and it should be correct. And it's really that straightforward. And the idea that there's no limits on what the other side can do because at-will doctrine is also false, because in Mayer's court said you cannot terminate somebody for an illegal reason. Breaching a contract, refusing to keep your end of a bargain is an illegal reason. So I don't really view this case as would be expanding the law. I do believe it should clarify the law that when you owe somebody benefits, you got to keep your promise when someone works in exchange to get them. And I think that's really it. As far as the damages side of this, there'll be ways to calculate that in a jury trial, but that's, if the case doesn't settle, I think it should settle. But the bottom line is that that's a remedies issue. It's not a consideration issue. So for those reasons, I think the trial court didn't understand the record or didn't see what the record really stood for when it granted summary judgment and threw out my client's two claims. It made a reversible error, and I respectfully request that that error be corrected, this case reinstated for jury trial. Thank you.
Attorney Conway, how do we, what impact do you think that Mr. Jones's review had? I mean, there was talk about the company growing and he having a position as a computer-assisted drawing position with the company. I'd like to hear your thoughts on that.
I think that the company groomed him. They gave him incentive to stay. And when you give somebody incentive to stay, it's like the Kelly versus Georgia Pacific case, same story. You give someone the incentive to stay and not look for another job, which Jones did, and you say that we're going to pay you a raise on top of that.
Well, I think they said he was fit for the job, or he'd be a good person for the job. Did they? They never really offered him that position, though, did they? They
gave him the duty, Judge. They increased his job duties. They may, I don't know what their story is with the change job title, because I never really got that straight. But the fact of the matter is they did increase his job duties significantly. So whether or not they granted him the title change is I don't see that as controlling. I believe the court should measure the conduct, not the not the appearances. And the bottom line is my client did more work than he was getting paid for and then didn't get the raise. And Clues admitted in his deposition, as I briefed it, that they were going to let him do that extra work and then not pay for it. I mean, these guys were dishonest. And I just don't think that should be allowed. I just think that should be dealt with in front of a jury.
All right, thank you. I think Judge Callahan has a question.
Sure.
Conway, if I'm correct, you pled this as a breach of contract and then also as a promissory estoppel. Am I correct in that?
Yes, yes.
And I understand you can plead both, but legally, are they mutually exclusive?
Yes, but I pled that in the alternative.
Sure. Okay.
And at trial, I would have to elect remedies. But because we haven't reached trial stage, I haven't elected remedies.
Okay. Thank
My
you.
inclination, though, Judge, would be to go with estoppel. That would be my inclination.
Okay. I guess I'm just asking because I'm curious about the judge's decision, but I guess we'll cross that bridge when we discuss it. Thank you.
Sure. If there's
All right, with
nothing
that,
else-
you'll have a full 5 minutes if you're,
Okay.
about 15 seconds if you want to use them, Attorney Conway, but otherwise we'll give you the 5
In that case,
minutes.
just give me the judgment and we'll be fine.
All right, you'll have 5 minutes for rebuttal. Let me reset the clock here and we'll hear from Attorney Kelly. Go ahead, sir.
Morning. Thank you, Your Honors. May it please the court. My name is Brian Kelly from France Ward, and I represent the appellee, PPR RICO Manufacturing. There are certain things that Attorney Conway and I agree on, and that can often help move a case along. And I think what we can agree on is this is a very simple case. In fact, this case could be disposed of very easily. Every argument, whether as Your Honor, Judge Callahan asked whether it's a promissory estoppel or a breach of contract case, there is one part of the deposition that takes care of every argument, assertion, inference that Attorney Conway has suggested here. And that goes to Attorney Conway's suggestion that there was a promise, an agreement, something to provide the plaintiff a pay increase. And the problem with the case, and what makes it so simple, is that we don't have the luxury of talking about what are creative arguments, interesting facts, or anything of that nature. What we have is a record. We have a very well-developed record from the court below. And part of that record is where the plaintiff, not one of the attorneys or anybody else, but where the plaintiff was put under oath. And the plaintiff was given the opportunity to explain what promise was made to him. And he was very specific, very specific. At page 44 of his deposition, he was specifically asked, quote, question to him, the promise was that there would be an additional meeting to discuss the merit increase, right? Answer, that is correct. What we don't have anywhere in the record was ever a promise to provide this individual with a wage increase. So whether this is a promissory estoppel case, which would require a clear and unambiguous promise to provide a wage increase, whether it's a contract case that would require an offer and an acceptance to provide a wage increase. Either way, what we need at the core of it is something from the company promising or agreeing to provide him with a wage increase. That's what's lacking. And that's why this case is so simple. To the extent also that the promise, according to the plaintiff, was that there would be an additional meeting to discuss a merit increase. The plaintiff also testified a couple pages later in this deposition at page 46 that that meeting took place. Testified very clearly, described that meeting. So that was the promise here. There was never a promise to provide a wage increase. A couple things that I think are worth clarifying, or perhaps, I'm sorry, Your Honor.
Would you hold your thought as to those
Yes, ma'am.
couple things? Can I ask you a question about what you just said? If I have my timeline right, Mr. Jones, I think first asked for a raise in October of 2017 and was told, you know, we'll think about it, we're going to have a meeting. And then there was that meeting. But, you know, the way I look at this, it was like 8 months. If I'm reading the brief correctly, again, I haven't read the deposition. And he was, I think, like repeatedly told, it's not like there was one meeting. He was told, you know, I'll talk to the supervisor, we'll have another meeting. Isn't that kind of stringing him along?
Well, it's the timeline is that it was in October 2017. He claims he asked for a meeting. In January 2018, he had that meeting, and he was told at the time that he was told at the time that he was not getting a wage increase then, and that Mark Bradley would talk to Jesse Clues about it. And it was very clear at that point he wasn't getting it. Regardless of whether he was being strung along, that would give him perhaps an opportunity to say he was unhappy in this job, Your Honor. Perhaps he would say, I want to leave this job. What it does not do is then amount to a promise that never took place or a contract that was never formed. So the question for us in this case, and for Your Honors in reaching decision, is not whether BPR RICO strung him along, was perhaps a bad employer where he should have chosen not to work or anything like that. The question is whether an enforceable promise was made or an enforceable contract was entered into. And your question is very apropos about a wage increase in Michigan, and that's one thing that I want to make sure we did clarify. Attorney Conway stated in his opening that the plaintiff worked for 2.5 years at this company and never got a wage increase. That's false. And I know sometimes there's lots in the record and confusion happens, but when the plaintiff joined this company, he got a written offer letter that said, you're coming in as an engineer, we're going to pay you $87,000. If provided you're still here after 6 months, you will get a $5,000 increase from $87,000 to $92,000. Plaintiff acknowledged he hired in at 87. He was there 6 months later. His salary increased to $92,000. So it's incorrect to say that he worked there 2.5 years and never got a wage increase. He got a $5,000 wage increase. The company determined that his salary was appropriate from that point going forward. A couple other things that I believe are important to clarify for purposes of the record. There was an assertion made by Attorney Conway that at the end of the plaintiff's employment, he was put on this performance improvement plan. And the line or the quote from Attorney Conway was that was directly related to his asking for a raise. Well, the record evidence, as opposed to an attorney's, is just the opposite. The witness who made that decision was Jesse Clues. He testified in his deposition that was not, him asking for a raise was not the reason why he was put on this plan. It's at page 19 of Jesse Clues' deposition. He was absolutely clear about this. To the extent the rest of the arguments that have been made here this morning are along the lines of, as Attorney Conway said, that he believes that the law should be clarified to make it clear that if you make a promise to someone, you have to keep that promise. There may be a vehicle, there may be a case that may come before Your Honors where it's important to clarify that if somebody makes a promise, they have to keep the promise. This, however, is not that case, because despite having briefed this now in the trial court and before Your Honors, what we have not been shown was a promise to provide this individual with a raise. Whether these assertions that he was groomed or anything like that, again, interesting, but not applicable to a promissory estoppel or breach of contract claim. Also, one other item for purposes of us talking about the record evidence, there was an assertion made that Jesse Clues, the supervisor, admitted in his deposition that the plaintiff was given extra work and not paid for it. That's also an incorrect reading of the testimony. What Mr. Clues testified was, as you've seen in the record, that the idea was there were going to be some new duties as some of the business transformed. There was no testimony of these as additional duties, that it was going to be more work for the plaintiff. But regardless of that, whether they were new, which is what Mr. Clues testified, new as in different as opposed to additional, it just doesn't matter. The plaintiff was a $90,000, $92,000 a year salaried employee. His job was to come to work and do the work that was assigned to him, whether he was doing this type of project one day, a different type of project the next day, this being new duties. That doesn't somehow turn back the clock and make something into a contract or a promise. When any individual in this type of setting comes to work, he or she does the work that's assigned, and that's that. That person may believe that it would be desirable to get a raise. Everybody, I imagine, believes they're doing well enough that a raise should come at any given time, but that doesn't transform under Ohio law into an obligation, and it certainly doesn't transform into an enforceable promise. So all of these arguments about fairness of keeping promises and things of that nature, as I said, I don't mean to belabor the issue. While they may be correct on some type of moral level, they have no applicability to the record before us in this case, or the law as it needs to be applied to these facts. I believe that the trial court got it correct. I would ask your honors to affirm that decision. And if you have no other questions, I will yield back to Attorney Conway.
Judge Callahan, any questions? Judge Hensel, any questions? All right, thank you, Attorney Kelly. Attorney Conway, you will have your 5 minutes for rebuttal.
You know, what really is simple about this is what's not being mentioned. That is, over the 8 months my client demanded his merit raise. He was never told, no, he's not getting one. That's what's really simple about this. Judge Callahan asked a question about, well, is he being strung along? The answer is absolutely yes, he was there. And the performance improvement plan was directly related to him demanding a merit increase. It even says so in Exhibit 13, which is the performance improvement plan itself. And as far as what Clues testified to in his deposition, it's also clear that I asked him, quote, a question, bottom line is that my client was given new job duties and the company wasn't going to pay him for the extra work. They're going to keep him at the old pay level, correct? Witness, correct. You know, these guys are taking something that they created, which is the impression that the claim that that, you know, my client's getting a raise, but every time he went to discuss it with him after doing the work to get it, they said, we'll talk about it later. It wasn't he was getting a promise to have another discussion about getting the raise. That's not what his deposition says at all. If you take it in context and you look at the entirety of it, going through over to page 48, he has repeatedly asked from October 17 to June 18, when am I going to get my merit increase? And opposing counsel keeps trying to get him to admit the promise is something other than getting the merit increase. So this isn't a situation where my client said, I bargained to have a meeting. No, he bargained to get a raise, and his labor was performed in exchange to get it, which is consideration for an implied contract, as if working for a bonus and then not getting paid it after doing the extra work to get it. It's also certain and definite enough to say, I did this extra work because they said I'm going to get a raise. And every time it came to discuss it, they brushed it off. But the one thing they didn't say, which distinguishes all of the above arguments, is no, you're not getting it. That could have ended the debate right then and there, but it didn't. And moreover, the case law is that whether or not there was an enforceable promise are questions of fact for a jury to decide, not the trial court judge. And context is very important, because in a labor and employment dispute, we're not talking about like you promised to paint my house for $5 and you didn't paint it. This is, I did the work and I didn't get comp for it. And how convenient of the defendant to say, oh, well, everybody's job duties change. Everybody wants a raise. That may be true, but the fact is my client actually worked to get it. That's the difference. Those are the facts. And as I noted with respect to my client's supplemental authority, the difference between that case and this one is, in the supplemental authority, the plaintiff in that case was told, no, you're not getting something. You cannot find anywhere in the records in this case, and I mean nowhere, you cannot find where the defendants tell my client, you're not getting a raise until they put him on a performance improvement plan because he asked for one. So we have questions of fact here that a jury can find in favor of the plaintiff with. The trial court did not get this right. And the entirety of the other side's MSJ argument was because my client's an at-will employee, he has no rights. They never got into this detail at all. It was all about, because you're an at-will employee, you don't have tenure, you can't claim that, you know, you have a right to get a raise. And that's just not the correct analysis, because it doesn't fit. It doesn't fit the facts and circumstances in this case. This is about, I worked for pay, I didn't get the extra pay. That's what's simple. They could have ended this whole thing again, last time I'm going to say it, by saying, no, you're not getting a raise. But no, they stood around and they accepted the benefits of his labor and then didn't want to pay for it. That's why there's an injustice. That's why equity demand screams out for injustice in a case like this, because they got something for nothing at my client's expense. I respectfully request the trial court be reversed. There is a question of fact for trial on the evidence in this case. And I believe the deposition records, when they're read in context, they do, in fact, refute the simplistic analysis opposing counsel is trying to use to carry the day in this case. Thank you.
And that was at 4:57, so used up all of that rebuttal time. Thank you both for your arguments. It was a well-presented case. On behalf of Judge Hensel and Judge Callahan, we appreciate you also appearing by Zoom here this morning. Of course, we're going to take the matter under advisement, issue a decision in due course. Each of you will receive a copy of the decision. Clerk of Courts will mail it to you on the day it's released. And as I'm sure you're both aware, the court's opinions are also posted on the Supreme Court of Ohio's website.